As a business attorney, I do a lot of work for businesses, but I also work with influencers and entertainers and athletes and all the people. And, we draft contracts and we negotiate the contracts and we get the great deals, but sometimes people breach contracts. Now, if someone has an obligation to do something and they don't do it, what you want to send is a demand letter. And so I thought you might find it valuable to actually go through, and I'm going to give you a little training on how to do this yourself. It's what I do all day long. It's been almost 10 years now. I've written a lot of demand letters. And the nice thing is that there's a formula to how to do it. Okay, so without further ado, please be sure to give this video a like and share it with someone if they're going to find it helpful. I'm going to share my screen. All right, so I left my letterhead on this. This is my law firm. So if you have a company, it always helps just to have a little formality of some kind of letterhead or logo. So if you have your own company, you work for a different company, throw something in there because it just makes the letter overall seem a little more professional. And at least for me, I kind of joke with clients. I go, half of what you're paying for is for me to add my letterhead to this letter because it just makes it a little scarier because it's coming from a law firm. Anyway, so let me make this a little bigger so you guys can see. All right, so you just basic stuff, have the date. I put a future date on this. So you're watching this at some point in the future. And then you want to specify, is this going by email? Are you sending it by US mail? Now, the reason why this matters is because you want to make sure that if there's a contract and someone breached the contract, comply with what the contract says. And so if it says, if there's a problem and you need to send a notice, that this is how you do it. So it usually specifies, send it to this email, send it to this address. Please make sure you read that and do what it says, because if you do end up sending a letter and the letter goes to the wrong person, then the company on the other side, the person on the other side, they can go, well, you sent it, but it doesn't matter. So specify the name, who's it going to, the address, the email, and please always send a copy by email. People just live in emails a little bit better, and so they'll get it faster. So make sure you send a copy to someone's email. And then put the title right here. What is this demand over? And so, if it's in regards to a certain contract, please just state the title of the contract, breach of the contract, or demand for reimbursement, just something real simple. Specify what this is about. And then also, once you have your great title, that's what you should copy and paste into the subject line of your email when it comes time to send it. Okay, so you just did all the work, just copy and paste. So we're gonna start off salutations, dear. Mr. is great, Mrs. is great. You can use a first name if you want, dear Larry. It's okay. But again, in the formalities, it's nice to just start the salutations with a dear. And then for us, of course, we're always gonna come out big. We're gonna say this firm has been retained by, state the name, hereafter our clients. But for you, if you have a company, then say, we represent. And so, on behalf of this person, this artist, this band, whatever it is that you do. Okay. And if it's just you, just say that. Say, I am writing this letter in regards to the agreement that we had dated XYZ. Okay. So this is, adapt this a little bit. But if you are going to say, I'm representing someone else, sometimes it's really helpful to define words. This is not required. This is just something that we as lawyers do because it helps us to, so we don't have to repeat ourselves, right? So if I go, super fancy name LLC as a company, I go, I represent super fancy name LLC. I don't have to write that over and over and over. So what you can do is put little quotation marks of how you're defining it. So you go here after the client, the artist, the contractor. And so then specify, what's this about? So you could just say, hi, I'm writing you in regards to the agreement that we signed. If you want, you can define it, the agreement, and say who was it with, which is usually the recipient. So in this case, we go with ABC LLC, which is hereafter the company. So again, the definition's not required, but it's just helpful. And then just give a little summary. Okay, get to the point. I'm writing you because we had an agreement. You said you were going to pay me for the services in the agreement that we specified by this certain date. You haven't. Very simple. And then the last part of this first initial paragraph is then to say, well, then what do they need to do? Give a deadline. I need you to respond to this, or I need you to pay this certain amount of money by this certain deadline. And please, please underline, please bold, specifically with by this certain deadline. Make sure it's very clear. And that's really it. Okay. So your introduction is done. And that's the formula that you use to really make a good impact. Because it's not about emotion, it's not about feelings, it's just being very factual. This is what it is, and this is what you need to do. Now, if you want to do something that is a little more formal, this is kind of how we structure the letter. So we'll say, factual background, and let's go in and give a paragraph, maybe a couple paragraphs, and just explain what happened. We signed this agreement on this certain date. And then I did what I promised that I was going to do, which was, let's say I provided contractor services and I made you some graphic design and I sent it to you. And you, in return, were supposed to pay me. You didn't pay me. Okay, so we're telling the story. You didn't pay me, and then I sent you an email, and then you said, it's coming, and we went back and forth, and here are the dates, and then you emailed me back, and then I emailed you back. So you do have to specify it in that kind of detail, but it helps because then you go through and you tell the story. So that factual background is just you telling the story and just be concise. Again, try to keep emotion out of it. Just be very factual. And then here in section 2, we usually do a claims section. Now, this is where if you do have an attorney, it helps a little bit because the attorney can be like, here's the case law and the statute and why we're just going to annihilate you in a court of law if you don't do what we're demanding. You might not be able to do that, but what you can do here is just generally state, I have a breach of contract claim against you. And usually it says it in the contract. If we have a problem, it says I have to sue you in the state of Arizona, for example. And so you can just say, my claims against you are, and what's pretty common is we have breach of contract, we have something called breach of good faith and fair dealing. So this is just, very simply, if someone acts in bad faith, I hired you to make the graphic design and to give it to me, and then let's say you knew I had a deadline and you were late on the deadline. So not only were you late and you breached the contract, but you acted in bad faith because then like a week later, you ended up, not only not giving it to me, so I didn't have time to get someone else, but then you were talking badly about me online. So there are a bunch of claims that you can specify, but very popularly are breach of contract, breach of good faith and fair dealing, and what's called unjust enrichment. Okay, so if one side does something and the other side doesn't do what they agreed to, then you may have a claim for unjust enrichment because someone was unjustly enriched and they didn't do what they said they were going to do. So anyway, those are just a couple of, quick examples that we do pretty often. So then let's talk about what you want to have happen. So typically we'll do a demand or what's called a Rule 408 settlement communication. Now, I don't want to get this overly, confusing for you, but under the federal rules of evidence and then the rules of evidence for the state that you live in, there's a rule, and it might be different depending on where you're at, but it just says that we're allowed to have private kind of communications, confidential communications to try to resolve the issue. And the reason why we slap on, a little title and we say, hey, this is a settlement communication is because, usually that prevents them from using anything that you put in the letter against you to prove their claims. So it's just a way that we can kind of speak freely and not have to deal with, having the letter presented in a court of law later on. So anyway, not to overcomplicate it, but all you need to do here is just what are you demanding? And so specify it here. Now, what's pretty common is you go, we had the contract, you owe me $2,000. So the demand is I'm demanding the money you never paid me. So very clearly just specify it. I love bullet points. So for a demand, I just make it super clear and I'll use bold. So let's go in. So I'd throw in a bullet point and I would say, payment. Let's make it super simple. Payment. And then, if let's pretend you had specified, the contractor is who owes you. So you go contractor to pay, and maybe you specified yourself as company to pay company $2,000 by, and then set a new date, and say, Friday. You can go in and do bullet points, pay me by the certain date. Maybe if this is coming from a law office, often we demand reimbursement of the attorney's fees. Maybe someone said something bad about you on social media, so you go look for settlement. I'm willing to not sue you. And in exchange for that, you pay me, you make a statement, and you say this kind of thing on social media to clarify. And so you just kind of, again, outline what you want to happen. And then let's go back. Here we go. We're bringing it home. The conclusion. So you want to kind of reiterate what you had put in the first opening paragraph here in the conclusion. So you go reiterate what it is that you want and also When do they have to comply by? Now, the thing that you're going to do, the super secret sauce of what makes a lawyer letter so effective that you can do, is that you're going to say, if you don't do what I put in my demand section, here's what's going to happen. And what typically is going to happen is you're going to file a lawsuit in a court of competent jurisdiction. You're welcome to take that phrase. You're going to file a lawsuit in a court of competent jurisdiction, which usually just means you're going to file where you are supposed to, if it's in the contract or if it's where the parties live, and that's it. And so, you want to make sure you come out really strong, be firm. And what's actually going to make your demand letter that much more powerful is that you're not going to put emotion into it, man. Don't have underhanded jabs. Be very, very factual. And, again, to the extent that you can put something like this together, and then sign it and send it by US mail, send it by email, it's really going to make a big difference as far as impact compared to, let's say, you sending an email and you go, "Hey, John, you suck. You breached the contract." I mean, again, you're saying the same kind of thing, but when you do put it on a letter and you have formalities, it becomes very powerful. And then if it's a serious enough situation and you want to funnel this up to an attorney and get some help, please do, because that can really make a big difference too if it is coming from a lawyer. So if you are looking for help, feel free to reach out to Delgado Entertainment Law and we'll see what we can do to assist.